And it looks like some are joining in. Remember, if you can turn your microphone on mute, that might be helpful. I know we've got maybe one or two people calling in too. So same thing would go for those of you on the phone. If you can maybe mute your phone, that might make it a little bit easier for everyone to hear. Let's start off just by making sure that everyone can hear me and see me. So if you can both hear me and see me, raise your hand. Okay, good. It seems like it's working for everybody. Today, I think we can kind of streamline today's session a little bit in the sense that we're really just going to spend some time talking about the assignment that you had for this week, which of course was to draft kind of a rewrite of the judicial opinion. So I thought we would spend some time discussing that assignment in some detail. And then beyond that, really, I think we'll kind of conclude our discussion of the broad category of documents that fall, the documents that fall under the broad category of informing and persuading. And that will really kind of close out our semester so that there will be no new reading assignment and no new drafting exercise for this coming Saturday. There may be a few of you, a couple, who maybe need to go back and finish up something that you haven't quite yet turned in just because of some craziness. Is to have come in and really we'll just talk about the final drafting exercise, the final portfolio project that is, which will be due probably 1 after that. So my understanding is that the next class will be our last class. And because it's our last class, that will be the time that I will assign the final portfolio projects. And then I'll at that point, give you a due date to turn those in. Any questions or concerns about that, or kind of any questions about where we're going from here? Basically, today we're going to talk about the final drafting exercise, the judicial opinion that you did, and then we'll, sign out and come back next week, and I'll assign the final project. Okay, I don't think anybody has any questions. So let's talk. I'm going to open up on my website. I went ahead and updated our website. What you'll see really is the only thing that was updated was the syllabus, just to reflect the fact that we're going to talk about the judicial opinion today, and that there's no new reading assignment or drafting exercise because we've pretty much finished out the course except for the final portfolio project, which I'll assign next week. So just pulling up the drafting exercise for today's class, of course, that was the rewrite of Watson versus McLean. There was still maybe, my laptop I didn't do my best job. I didn't feel like I did, at least, kind of articulating in a clear way what I was hoping to get out of the assignment. But the big picture takeaway was I wanted you to basically rewrite the entire opinion. I wasn't really looking for kind of line by line edits. It's definitely a comprehensive opinion as it's currently written by a federal district court judge in the Northern District of Ohio. It's certainly comprehensive, but the lesson I was trying to kind of the point I was trying to get across was, although it's very comprehensive, I don't know that it's necessarily persuasive given the way it's written. A lot of boilerplate language with respect to both the standard of review and the substance of the law as it relates to the Eighth Amendment. I wanted you to think about basically taking this opinion, either printing it off or kind of putting it in a side window on your computer, and then opening up a new Word document and basically retyping a new opinion based on some of the information that's in here, but a lot of it you could probably leave out. And so with that in mind, I could spend a lot of time talking, but I want to hear about somebody who, also worked on the opinion. So let's see here. Let me see if I can call on somebody I haven't maybe called on. How about Amy? I'm not sure that I've talked to you recently. What do you think, Amy? How did you approach the assignment? What did you think about, how you could have streamlined the opinion and made it both not just informative to the reader, but also more persuasive?
Well, I kind of approached it like we were talking about last class, and doing a very short and concise opening, just saying that, like, he's a prisoner confined without a lawyer. He's claiming that these prison officials ran afoul of his rights under the 8th Amendment. That was, like, my first paragraph.
Yeah. Exactly. I think we spent some time. Go ahead.
Then I went into kind of my summary. So it was like, he's failed to state a claim, an 8th Amendment claim. This is because he has not shown that he suffers from a serious medical condition. And even if he did, he hasn't established that they displayed a deliberate indifference. And thus, he has failed to state a viable 8th Amendment claim.
Yeah, good. I mean, I think Amy's clearly articulated kind of what we're looking for when we're drafting a judicial opinion, which is an initial paragraph or maybe 2 paragraphs at the beginning that function as your bottom line up front. That's really missing here. If you look at the opinion by Judge Helmick, there's no kind of clear thesis at the beginning. And he definitely gives a little bit of background as far as who this pro se litigant is. History of the case, but it really ends up just being a fact section. And you don't really have any sense from the beginning of the opinion what the answer is. You don't know where this is going. Is it a viable claim? Is it not? I mean, it's about medical care that he allegedly received at the correctional complex there in Ohio, but you don't really have a sense of where this is going. And so I think, one of the things we've talked about kind of consistently throughout the course, whether it's with a memo or an email or a judicial opinion, any form of kind of descriptive, I would say, or a writing that you're both trying to inform and persuade, you want to kind of give the reader some clarity about where this whole thing is going. And so I think Amy has kind of accurately stated how she would rewrite the intro, the thesis section, the kind of, bottom line up front paragraph or 2 paragraphs to kind of make it clear, yes, like, here's who this person is. He's a pro se litigant, a prisoner out of the Northern District of Ohio, and he's claiming that he received legally inadequate medical care, but kind of quickly saying up front, although he alleges that his 8th Amendment rights were violated, he fails to state a claim for 2 reasons, right? He was either a serious medical condition, but even if he did, he has not demonstrated that prison officials were deliberately indifferent to his serious medical needs. So that, I think Amy's got it, right? That's the bottom line up front. And kind of, we talked a little bit about that in class last time. Once, though, Amy, you get past that kind of bottom line up front, proof-like style of writing at least an intro or a thesis or an opening paragraph, in a judicial opinion, what's your next section going to be?
So my next section was just like a really short, concise description of the facts.
Yeah, fact section. I mean, there's really no kind of one way to do this, but you want to try to make it roughly chronological, right? We always have what I call facts and then procedural facts. What I mean by that is, what factually occurred first with respect to this individual. So what are some of the facts that you talked about in that part of your fact section?
I originally started out with like what his medical condition was, so that it was a seasonal skin condition in May of 2012.
Yeah.
And then I stated that he had been seen by 5 doctors and 1 physician assistant over the course of 1 year. And then I talked about each doctor had diagnosed him with a condition and prescribed a remedy. And then I talked about what those remedies were.
Yeah.
And then I say he still claims that each of these treatments was ineffective.
Mm-hmm.
And so I didn't go into the history of the litigation, so maybe that's something I probably should have added in after that.
Yeah, I think often, especially when you think about a judicial opinion, I mean, I do think it's helpful once you kind of lay out a narrative summary of what happened to this individual factually. I do think it's helpful if you can do that in kind of a clear, concise way, active voice, right? Of course, proper grammar, punctuation, spelling, all of that's got to be kind of on the up and up. And once you do that and you kind of have a story that somebody can just read it in a narrative way, like, oh, okay, now I know what factually happened. And I do think it's helpful to have a paragraph or two that kind of leads you from what happened factually to the person at the prison to why this case is before your court, right? And you want something really simple, like, after all of this happened, he filed a lawsuit in federal district court. Here's what he's claiming, and now the defendants moved to dismiss, or the case is before the court on an initial screening, or so that it's clear to the reader not just what happened to the person factually, but why you as a district court or a circuit court or the Supreme Court or whatever court you are, state or federal, why you're analyzing it. And it might be because he filed a complaint and it went through discovery and the defendants moved for summary judgment. It could be that he filed a complaint and the court is conducting an initial screening of the complaint under the law. It could be that he filed a complaint and that the court held an oral argument and now it's before the court on some other dispositive motion. But I do think you want a thesis. And then I think your first substantive section is a fact section that includes both facts, meaning what happened to the person in a factual way, a narrative sense, but also procedural facts, so it's clear to the reader why this case is before the court on a judicial opinion, like why the court is issuing an opinion at this moment in the litigation. So good. I think it ought to be clear to the court that basically we're before the court on a motion to dismiss stage, right? And we're trying to determine whether the plaintiff, when we construe the facts in the light most favorable to the plaintiff, if the plaintiff has stated a claim under the Eighth Amendment. So you want to make it clear the plaintiff filed a complaint. He's alleging that these various prison officials displayed a deliberate indifference to his serious medical needs, and therefore he's seeking damages. In response, the defendants moved to dismiss his complaint for failure to state a claim upon which relief may be granted. So when you get to the end of your facts section, which includes procedural facts, it's teed up so that the reader knows, okay, the court is about to tell me whether or not the plaintiff has stated a claim under the Eighth Amendment for deliberate indifference. And the reason why I do think it's important to include that procedural part of your facts section is that you want your analysis to be one that starts out with the answer. And in a way that might feel like you're getting a little bit blindsided because it is the answer up front. You're not really getting blindsided because the end of the facts section led you to believe, hey, the court's about to analyze whether or not the plaintiff has stated a claim upon which relief may be granted. Does that make sense, Amy?
Yes, it does.
Okay, so now, Amy, when you started your analysis section, right, which that was your second substantive section, correct?
So I know that you said to not really include a standard of review, but I felt like some of it was a little necessary, so I picked and chose what to include. So I don't know if I should just take that completely out if it's unnecessary, but I guess I erred on the side of caution.
Well, it's interesting because, I think I say all this, and a lot of courts, look, this is an opinion from a federal judge out of the Northern District of Ohio who included multiple paragraphs of a standard of review in a judicial opinion. So, I certainly ought to be humble and recognize that, there is clearly a difference of opinion here. There are a lot of different views about whether or not you need a standard of review section. I am of the view, and I think some other people are also of the view, that if you can avoid these kind of boilerplate paragraphs, it is more persuasive to the reader to just immediately, kind of be told what the answer is up front. And I think the way you streamline this is to mix in some of the standard of review language, if you feel like it's necessary, into your analysis. And so if you end your fact section by saying something like, a paragraph with procedural facts, including something like, the plaintiff has now filed a lawsuit in federal court. He claims that the various defendants, all of whom are prison officials, displayed a deliberate indifference to his serious medical needs in violation of his rights under the Eighth Amendment, period. Therefore, he's seeking money damages. And then say, that said, the defendants have now filed a motion to dismiss his complaint for failure to state a claim upon which relief may be granted, and thus this matter is pending a decision before this court, period. That's how you end your fact section. If you start your analysis section, if you want to, make it clear that it's before the court on a motion to dismiss standard, and that's a very kind of deferential standard to the plaintiff, you could say something like, you could start your analysis by having a bottom line up front, which says something like, Watson has failed to state a claim upon which relief may be granted, period. And then you could say, even construing the facts in the light most favorable to Watson, as is required under the law, and then cite a case. Even doing that, he has still not demonstrated either one or two. Does that make sense?
Yes, that does.
So I think, that the reason why, and this goes back to something we talked about last class, which is like, hey, why? Maybe it was Alexander, Anthony. I'm not sure who I was talking to last class about it, but I was talking something, and I think the question I put to the class last time was, why do it this way? Like, why do it the way the judge wrote this opinion with standard of review sections and, long paragraphs of law that really could be copied and pasted across Eighth Amendment cases? And I think we had a lot of good answers, right? I mean, a lot of students gave a lot of thoughtful answers. I think Kirby was involved, Kyler maybe. All of you gave good, thoughtful answers. But one of the things I really wanted you to take away was it's just kind of easier to write. It's easy just to drop a bunch of standard of review paragraphs and boilerplate Eighth Amendment paragraphs. And law students love it because they, in reading cases, can learn about the Eighth Amendment and learn what the law is. But if you're really trying to draft a legal document in a way that's most persuasive, I think moving away from the boilerplate to more kind of direct, active voice statements that give the answer up front and then try to prove why the answer is what it is, leaves the reader convinced that the court has reached the right answer, as opposed to, hey, this is what the case is about. We're not going to tell you what the answer is up front. We're going to copy a couple of paragraphs on the standard of review. We're going to copy and paste a couple paragraphs about the Eighth Amendment, and then we'll analyze it and come to a conclusion at the end. That, I think, is easier to write. It takes less time, but I also think it's less persuasive. It's not as effective when you think about all of the things we've read about in legal writing. I don't think it's quite as persuasive. It can inform, but I don't think it's as persuasive. And so if we take that, if we move along, Amy, we're thinking, okay, we've got a thesis that sounds good. We've got a facts section that includes both narrative facts and procedural facts. And now we've got an analysis that starts with your bottom line up front. It starts with language that probably sounds very similar to the end of your thesis, right? The end of the opening, which also gave your bottom line up front. So what's your thesis, Amy? What was your bottom line up front answer? And I say all of this, and now I'm realizing that Amy looks like she's inactive. I don't know what happened. I hope it didn't scare her away. It looks like she left the session. Maybe she's having some computer problems. Who can help? Can somebody raise their purple hand and help me out in Amy's place until she gets back? Who wants to help me with this? Who wants to give me their thesis? Amy, are you back now?
Yeah, sorry. I guess I don't have great internet.
No, that's okay. We thought we scared you away for a minute. I was about to call on somebody else. What my question was, what was your thesis? What was your, I'm thinking about the analysis. We've got your thesis paragraph. We've got your facts section, including both substantive facts and procedural facts. Now I'm thinking, okay, the analysis, if you sidestep a standard of review and just went to an analysis that had your bottom line up front restated there, what was your bottom line up front? What was your thesis?
In the very beginning, I put Watson has failed to state a claim upon which relief may be granted. That is because he has not shown that he suffers from a sufficiently serious medical condition. Moreover, even if he has not established that any prison officials displayed a deliberate indifference to that need.
Perfect. Literally perfect. I couldn't have said it any better. Okay, good. So now I'm going to call on somebody else. Taking Amy's perfect thesis, what about Joseph? If that's Amy's thesis, Joseph, and it's perfect, what is necessarily going to be our next paragraph? How are we going to begin our next paragraph in our analysis?
I guess you would start by with the first element of the Eighth Amendment claim.
Yes. Now that's exactly right. Okay, good. But the question is, how are you going to start it? Because you're right.
Yeah, you'd say Watson has not shown that he suffers from a sufficiently serious medical need.
Okay, that is 100% right. Now, why am I making a bigger deal out of this than it is? Because you've gotten the whole thing. Like, this is it with legal writing. This is what we've tried to get across. You all moving away from stating issues up front to stating answers up front. And we've done it now together, 2 consecutive paragraphs in a row. We've got our thesis, we've got our fact section, fact, procedural fact, we're in the analysis. We have Amy's perfect thesis statement right up front. That's your first paragraph. And now we're trying to build as a class the next paragraph of your opinion. And Joseph could have said, I would start with the first element of an Eighth Amendment claim by saying something like, the first issue is whether, or the first legal standard I want to discuss is blah, blah, blah. But no, he recognized that up front, you've got to then prove each of the elements that Amy laid out. And he said he didn't have a sufficiently serious medical need, and even if he did, he hasn't demonstrated that prison officials displayed deliberate indifference to that. And Joseph recognized, hey, we've got to first prove that he doesn't have a sufficiently serious medical need. But I've got to state that up front. So you're going to start your next paragraph by saying something like, Watson has not demonstrated that he was suffering from a serious medical need. So good. Now, Joseph, what's your next few sentences going to look like after that?
I said that that is because he doesn't allege sufficient facts that indicate he qualified or he had a serious medical condition. Yeah. And all he contended was that he had a seasonal skin condition. And then I talked about the law.
Okay, yeah. Hold on a little bit about that, though. Then, I mean, okay. I mean, I think we're saying the same thing, but what then did you say?
I'm sorry.
I think here's kind of what I'm thinking. We're on the exact same page, which is in your analysis section, you want to start out with your answer. And Amy's gotten us there, right? He didn't have a sufficiently serious medical need, and even if he did, he hasn't demonstrated that prison officials displayed a deliberate indifference to that need. Next, your first paragraph after that is going to be, he's not demonstrated that he was suffering from a serious medical need. The subsequent sentences have to prove that that's true. And the way I envision you doing that is having kind of a little bit of law to the side, right? Like you're in the back of your mind or on a page that you printed out or somewhere else, you're going to have like, what does it mean to have a sufficiently serious medical need? Because it's got to be more, and I know this, but it's got to be more than like, hey, I just don't think it's sufficiently serious, right? Like, who are we to say that a skin condition isn't serious? I mean, I'm sure we can find a lot of people who have serious. I have a good friend of mine who had psoriasis. His whole childhood, it was like debilitating for him. So, we can't just say it's not serious. What we would have to do is find some law, and unfortunately, it's in the opinion. It talks about aches or pains or medically recognized conditions. It talks about how you determine whether a medical condition is sufficiently serious under the law. And so what you want to do, since you're trying to prove that his condition was not sufficiently serious, is to read some of the law on that first element and then in your head, before you put pen to paper, kind of think, hey, does this medical condition that I'm analyzing meet this standard? And then you want to write it in a way that kind of mixes the two, right? That doesn't just say, oh, here's all the law on sufficiently serious, and here's the analysis of that law. You want to say something like, up front, his medical condition isn't sufficiently serious, and that's because of blah, 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 right? And you would say something like, that is because his condition falls or is analogous to other conditions that under the law have not been viewed as sufficiently serious to state a claim under the Eighth Amendment, period. Cite a case. For example, these conditions include but are not limited to conditions like dandruff, acne, chapped lip, dry hands, blah, 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 blah. So do you see how what we want to move away from is blocks of law and analysis of that law? We want to move towards proving up a thesis. If your thesis is this is sufficiently serious, you got to read law on serious, apply it in your head to the facts of this case, and then write sentences after that support your thesis. Does that make sense, Joseph?
Yeah, absolutely.
Okay. Yeah, the problem is, like, I can say all of this, and really, I don't know, I've been thinking about the class all day, kind of in preparation, and how I wanted to get this across, and and I want to say something too in a minute that's just triggered my head about us having individual meetings. And, this whole situation has made the class, obviously it's, remote. It's more challenging in a way, I feel like. And, my goals for this semester are different than they were when we started. But what I guess my big goal, and this is emphasized right now in this opinion, is I just want you to take away, if nothing else from the class, I want you to kind of rethink about your way of drafting documents, especially these types of documents, opinions, memos, emails, the types of things you're going to send every day to your partners and your associates that you're working with and your judges that you're interviewing for. I want you to move away from this whole issue analysis conclusion. And I want you to move more towards being confident in what you're saying and then backing up with what you're saying with arguments that support why you're saying what you're saying. And this opinion is the opposite of that. This opinion is issue rule analysis conclusion. And I just want you to take away that that's not the most persuasive way of writing. It's not the most, it's just not the most persuasive way. It can be informative, but I think people will be more persuaded if they keep getting hit by your argument. Hey, this guy failed to state a claim because he didn't prove these two elements. First, he didn't prove this one. That's because it requires this, and he didn't show this. And then after that, you could have a counter-argument that's like, hey, there is a case that I found out of the Western District of Michigan that suggested that maybe this was serious, but that case is distinguishable because of this. And so you just kind of keep punching with your arguments about, hey, this is why my answer is the right answer, and here's my support for that. What about the second paragraph, or the second, not paragraph, but the second element? How do you want to start that section of the opinion, Joseph? After you discuss the reasons why he hasn't stated a serious medical condition, what's your second paragraph?
Are you talking about the second element, right?
Exactly, yeah, I keep saying paragraph. Okay. I mean the second element, yeah.
Yeah, so I, again, say the conclusion up top, saying, second, Watson has not shown that the prison officials were deliberately indifferent to the serious medical need.
And why is that? Because you're right. Okay, so why? Give me your support for that.
Well, I said in order to prove prison officials acted with deliberate indifference, the inmate must show that prison officials knew of and acted with deliberate indifference to an inmate's health or safety.
Okay. Now stop right there. There's a little bit, again, this is gray. You've got your bottom line up front in that part of the opinion, but do you see how what you just said, it's going to sound like I'm picking on you, and I am in no way picking on you, or I don't mean to. But do you see how what you just said was a little bit of a reversion to the whole, like, I'll give you my conclusion up front, but then I'm going to give you law, and then I'm going to analyze that law.
Yeah, that makes sense.
Yeah, so what I'm saying, and that's not to say you can never do that, but what you could do is you could say, Watson has not demonstrated that the prison officials displayed deliberate indifference to his serious medical needs. That is because Watson has not alleged that any of the prison officials acted with a culpable state of mind, as is required under the law. Do you see that? And so then it's like it feels like instead of kind of going law analysis, you're giving more reasons. It feels like you're just getting a cascade of reasons why your answer is the right answer. Do you know what I mean? So it requires more work to stop and think, how can I rewrite this in a way that it supports my argument as opposed to state's law and analyzes it, right? Like, going back to my Starbucks Quills hypothetical, like if one of my reasons why you should go to Starbucks as opposed to Quills is because it tastes better, I could say, the second reason you should go to Starbucks instead of Quills is because it tastes better. And then I could say, under the law, there have been 5 studies done. Applied to these facts, here's what the studies say. Or I could say, you should go to Starbucks over Quills because it tastes better. That is because all of the studies that have been done indicate clearly that a majority of patrons think that the food at Starbucks is better than Quills. Do you see that? We're both saying the same thing. One is just law analysis, and another is analysis with the law mixed in, right? It's like he's saying, hey, is the defendant negligent? I could say the law on negligence is the defendant has to owe the plaintiff a duty of care. The defendant has to breach. The defendant has to cause the plaintiff's harm, and the plaintiff has to suffer damages. Or I could just say up front, the defendant is negligent because the defendant owed the plaintiff a duty of care. The defendant breached that duty of care. The defendant caused the plaintiff's harm, and the plaintiff suffered damages. And all of that is mixing the law and the facts, right? Kroger was negligent. Bottom line up front, Kroger was negligent. That is because Kroger owed Colin a duty of care. Kroger breached that duty of care. Kroger caused Colin's damages, and Colin suffered harm. First paragraph, Kroger owed Colin a duty of care. Then I could just able to say, under the law, here's the law on duty applied to the facts. Or I could just say, Kroger owed Colin a duty of care. That's because Colin is a customer, and under the law, grocery store owners owe customers duties of care. Thus, Colin is established the first element. Does that make sense?
Yeah.
I can hear my kids downstairs imagining. I guarantee when I go downstairs, they'll be like, "You were yelling again." And I probably yell. I don't mean to yell. But my point is, it gets to this kind of meta takeaway from the course, which is like, you're not going to remember like all of this. You're not going to, when you draft a memo for your senior associate, you're not going to pull out your legal drafting notes. I mean, that would be kind of silly. But what I want you to remember is there's a whole new way of writing. And it's this way, it's this persuasive way that focuses less on these kind of formulaic templates. This opinion right here, as drafted by the judge, or I should say maybe the judge's law clerk, feels very much like I'm just going to insert sections. Okay, I'm going to have my issue, and I'm going to say all the law, copy, Control-V, Control-C, Control-V, copy and paste it. Oh, now I've got my analysis. Now I've got my conclusion. And I'll be honest, I mean, I get cakes after cakes after cakes every day, and there are a lot of moments that I kind of do that just to move on to the next thing. So you've got to prioritize your time. When you guys send me your drafting exercises on Saturday, I keep sending you back the same emails. Got it, thanks, hope you have a great weekend. Got it, thanks, hope you have a great weekend. Why do I do that? Because it's an efficiency. So I get that life happens and that there are efficiencies, or the need for efficiency. But when we're thinking about drafting documents in the best way to both inform and persuade, I want you to think about this new way of writing. Okay? So we can keep going on, but the point here is, whether it's the email, whether it's the memo, whether it's a judicial opinion, any type of writing like this that's not technical, that's not like a complaint or an answer, but that is more kind of, descriptive in nature, or, that I would say fall under this category of informing and persuading, which would include motions, right? You can draft all of these documents in this kind of top-down, bottom line up front way that's proof-like, meaning like you're trying to prove an equation. Here's your answer, and here's why my answer is the right one. And the way I'm going to persuade you most effectively is not just to give you bodies of law and then analyze it. It's to take that law and interweave it with my analysis so it looks like another reason why my answer is right, another reason why my answer is right, another reason why my answer is right. And when a counter argument pops up, you can deal with that very quickly in a new section by recognizing what the counter argument is and then rejecting it and explaining why the counter argument is faulty, right? It's true that in the Western District of Kentucky, the court said this. However, that case is distinguishable because of this. Therefore, it's without merit. Or it's true that the defendant argues this. However, that's wrong because of this. And you, in a bottom line up front way, deal with the counter arguments that kind of come across. Are there any questions about any of that? I hope, if nothing else, I hope that the next time you draft a motion, an email, a memo, a judicial opinion, some sort of legal document that you have to draft, you think about writing in a way that's less formulaic, less like writing a law school exam answer, and you think about how can I really persuade the reader that this is the right answer. And you should do it even if it's what we might think of as a neutral piece of writing, right? Like you think of a judicial opinion as neutral. Well, I mean, it's neutral in the sense that the person who's resolving the case before him or her is resolving it in a neutral way. But the judge isn't biased in favor of Watson or McLean, right? I mean, the judge is resolving it in a neutral way. But once the judge arrives at his or her answer, they want to persuade the reader that the answer and the parties that the answer is the right answer, right? You're resolving the case that's before you. And so you want to make it persuasive, like, hey, this is the right answer. This is why the claim fails under the Eighth Amendment. It also gets a little bit into judicial philosophy, too. Like, why not give huge chunks of law? about the Eighth Amendment? Well, part of it is there's at least most judges, I think, and most litigants as well, see the need for avoiding dictum, right? And we all know what that is, right? Dictum is those parts of an opinion that are not necessary for the resolution of the case, right? So if you think about what the role of a judge is, and that, just as a footnote, this really ought to transcend kind of jurisprudential views. I mean, I think generally most people agree that the role of a judge is to resolve the disputes that come before the judge. And so when she's resolving the dispute that comes before her, she's thinking, how can I draft this opinion in a way that resolves that dispute? Not that kind of lays out, statements of law that are not necessarily relevant to the resolution of the case, or statements about the facts that aren't necessary to the resolution. So if you think about that the goal of a judge is to resolve disputes that come before him or her, then you're thinking about only including those facts and statements of law that are relevant. And that's consistent with what we're saying, which is, hey, write it in a top-down, bottom-line, up-front way that only includes what you need. And you only include what you need if you write it in this way, right? If you say, hey, this is the answer and it's because of A, B, and C, first, A is true, and that's because of E, F, and G. Next, B is true because of H, I, and J. You're only including what you need to prove up your answer. So there is a little bit of a jurisprudential view in all of this, or that's a reason why we would want to draft a judicial opinion, at least in this way. But I also think it ties into other things we've discussed, like clarity, conciseness, keeping it clean and tight and narrowly written. And I think everybody appreciates that, right? Like when you're a busy, senior associate or a junior partner or a senior partner, and you're reading something that people send you, you appreciate when the answer is clear and it's upfront and you're like, okay, I know where this is going. You might need a fact section that's narrative, but it's one that you can follow. And then when you get to the analysis, you're immediately confronted with, hey, this is the answer, and I'm going to tell you why, right? I mean, if you ask somebody a question, which is what we do in the law, hey, what's the answer to this? Short of a research assignment that's like, hey, find me all the cases that say this, or teach me the law on this, right? I mean, that is give me all law, no facts. But if somebody says, hey, here's my problem, I'm your client and I have a problem, do I have a contract with this person? Or, hey, I'm really pissed because my neighbor put a fence over my property line. Do I have any recourse? Or, partner comes to you with a question and says, hey, here's what's going on with Maria, and she wants to apply for cancellation or removal. Can she do it? They don't want you to come back with, sit down, let me tell you about all the law and cancellation. They want to know what the answer is, right? I mean, Watson wants to know, does my claim go forward? And the defendants want to know, is his claim going to get dismissed, right? The judge that you're writing this opinion for wants to know, how are we resolving this case? Like, what's the answer? My kids are like, hey, can I have my third candy bar out of my Easter egg, or out of my Easter basket? I could say, well, sit down. Let me tell you about Twix versus Milky Way, and let's have a body of law on this. And they don't care. They want to know what the answer is. That's all I tell them. No, you can't have a third candy bar for these three reasons. One, you already ate a bunch of candy. That's because you ate a Milky Way. You ate a Reese's. Two, you can't have it because you haven't eaten your dinner yet. And three, it's because I said no, and I'm the dad. So anyway, my kids are probably wondering what the heck. Any questions about that? Bottom line up front, proof that's all my way of trying to get you all to think at the end of the day, 6 months from now, 3 months from now, 5 years from now, when you're drafting this opinion, whatever it is, thinking about writing it in a different way. And in some ways, I think what I'm talking about, I think, is a little of a new trend, right? I mean, I think people are starting to wise up to avoiding legalese, writing in plain language, writing clearly, writing concisely, giving your answer up front. Clarity, clarity, clarity. That's what you want in your opinion. So I think it's a little bit cutting edge, but I also think it's a growing consensus too. I think people are recognizing like all of this legalese, these huge paragraphs of law that people just have to keep in their head as a reader makes it very difficult for them. I think we're starting as a profession to move away from that. But then I say all of that, and you read opinions like this, which I guess it's quite a few years old, right? I mean, we're coming up on 6 years old, but it's not like it's a 1985 opinion. It's pretty new. It's fairly modern. And you still see a lot of this too. So I don't know. It's a lot of words, but that's what I want you to take away. Honestly, especially given the nature of the class and how it's changed, we're thinking this whole semester less about, line edits and nitty gritty and more about kind of big picture lessons that you can take away in legal writing. And that, I promise you, is the thing I want you to take away more than anything. Any questions about that? Okay. The only other thing I wanted to kind of say procedurally about the course is, it occurred to me that my goal each week has been to try to read what you send me and try to structure the presentation or one of my talking points in a way that kind of not just reflect what I want to get across, but kind of respond to what I'm seeing in your submissions. It's also occurred to me, though, that it's not, I guess in large part because of the nature of the class and how it's changed moving remotely, it's necessarily meant us having less one-on-one interaction, certainly less than I anticipated for the semester. And so I thought about kind of like mandating individual conferences, and I was going to do that, absolutely going to do that before kind of circumstances changed and the nature of our course changed, the nature of the world changed. And so I'm not going to do that. There are a lot of you I know are just, I assume many of you might be dealing with, health-related issues, either personally or within your families, or just the stresses of moving away from campus for some of you that had to do that, or just everything that's going on in the world. I don't want to add to any of your stress by requiring you to do some other extra thing outside of our course, even if it's related to our class. So if you want to have these one-on-one interactions, I'm more than happy to do that. I'd be delighted to have an individual conference. We could even set it up over this Blackboard system so that you and I can at least have a kind of a face-to-face that way. But I'm not going to mandate because I know that it's a stressful time for everybody and I don't want to add to your but I wanted to put that out there. If you feel like, gosh, I don't feel like I've gotten the one-on-one interaction that I would have liked, I sympathize with that. And I wish I could have given you more of a one-on-one in this class. So if you want it out there, or if you want it, I put it out there as an offer. Feel free to reach out and we can have a one-on-one kind of meeting. But beyond that, really, the only other plan I have is, one, if you haven't turned something in, because you've fallen behind or, the circumstances are such that you haven't been able to get something in on time, that's totally okay. Feel free to use the next week to kind of clean that up and get anything in that may be outstanding. And really, I have no other substantive assignment for next week's class, no new reading assignment either. What we'll do, I think, just next class is we'll all log on here remotely, and I will have posted right before next class the final portfolio project. And it sounds, it's a big project. Really, if you wanted to think ahead to where we're going to go, it's going to basically be you going back and editing 5 of the 7 drafting exercises you've already done. You've done 7, but only 5 have been substantive in the sense that you did a complaint, an answer, a motion to dismiss, an email, and the judicial opinion. Those will be the 5 that you'll have to go back and edit. And then I'll have 2 short new ones. And that will be the portfolio project. So if you are ahead, if you've already turned in everything and you're kind of caught up, you might just go back now in the next week and just go back and edit your complaint, answer, motion to dismiss, email, and judicial opinion, and get it in a little bit of a better shape, at least one that you would want to turn in as part of your final portfolio project, so that when you get the assignment next week, the only other two things you'll have to do are the two new assignments. And we're only going to do two new things that you haven't seen before. And again, given the nature of the class, you know, I do want you to put your best foot forward on it, but at the end of the day, you know, it's a pass-fail course. And so, you know, if you've got your 5, if you take some time and you know, draft something that is your best effort on the other 2, put the 7 together and turn it into me, that will make your final portfolio project, I think, pretty straightforward and not too much heavy lifting, so that, you know, if you turn in all 7 documents to me as part of your final portfolio project, you know, you get a check mark and pass class and then move on. So, any questions? Okay, so I think we're about to sign off. No new assignments. If you haven't finished everything, feel free to turn it in. Otherwise, nothing due for Saturday. Just go back, start thinking about the 5 old things you've done, and we'll come back here on Monday, 1 week from today, and that will be our last class. And I will assign the final portfolio project, which will be those 5 old assignments you've done, and I'll give you 2 new ones. They're a little bit different, but, you know, very much on par with what we've seen. And in the meantime, if you want to have an individual conference to talk about what you've drafted, you're welcome to do that. I'd be delighted to talk to you, but I'm not going to require it just because of the circumstances. So we did it in under an hour. That wasn't too bad. Okay, I hope you all have a good week. If you need anything, feel free to reach out. Otherwise, please just be safe, healthy, happy. I hope everybody's doing well. Take care.
Hi, Professor Schuler. Can you hear me?
Hey, how are you?
I'm good. How are you?
I'm good.
I am halfway interested in an individual conference. And I say halfway.
No, that's good.
I don't have any clue how I've been doing. I felt really unsure. I've been writing for my boss for 20 years, and it's funny. I'm
back. We could do it after class. It's up. I mean, after the semester. It's up to you.
I'm not worried so much about being able to pass the class. I've turned in,
well, you shouldn't be. You will pass the class.
Right.
Yeah.
And so, but I am interested in getting some feedback just from what you've taught us. And so I don't care. I mean, I can do it next week right before class, or if it works for you better to do it after the class, I'm fine with that too.
Really, any of we can meet in the next week, because it might even be beneficial to the extent that you want to incorporate some of what we talk about in your final portfolio. So just go ahead, take a look at your schedule, and then find a day sometime in the next week, whether I'd say maybe Wednesday on, that would work well for you in the evening. And any of those evenings should be fine. I mean, my calendar is pretty wide open just given the circumstances. So.
Well, I don't want to take time away from your family, though, either.
No, it's fine. It's part of the job.
Actually, I know I can do Wednesday, but I don't want to push you too much. I can do Wednesday, or I can do Monday.
Is there a time on Wednesday that works well for you?
I usually work on homework stuff from like 7 to 10 on Wednesday. So if you want to do it when your kids go to bed at 9 or whatever you're doing, I can do that. Or
what if we shot for, let's say, 8 on Wednesday? Okay, so we'll say 8 on Wednesday. That's awesome.
Okay, and so what are you going to do? You going to shoot me an email with a link, or how do we work this out?
I think what you can do is just how you go on to Blackboard now. You could just go on to the Blackboard site and about 20 minutes before, 10 minutes before, I'll just create a new link, just like I do for class.
Okay.
And it may just say legal draft, but you are not the only ones that are going to be interested in joining on Wednesday at 8. So I'll put that out there. And
I'm not planning on taking all of your time. Maybe if we could just spend 10 or 15 minutes going over.
Oh, yeah, no, for sure. We can talk as long as we want. So, I mean, one of those things, too, where, I really thought all day about it. I was like, we should, this is a writing class. How are we not having individual conferences? Part of it, though, is I think so many people have so many things on their mind right now that I wanted to kind of make it like, hey, if you want it, you can have it, but I don't want to burden people with more things to think about, especially just, to be honest, I also know what it's like to be a law student, and I know what it's like to take a pass-fail class. And I think if students are thinking, I just want to check the box and move on, I kind of understand that. And so I thought, you know what, as much as you all want to get out of it, you can, but I don't want to add. Some people are dealing with God knows what, families and job losses, and I mean, unemployment. And the last thing I want is, hey, on Thursday, you better be online with me. Like, that sounds so not important right now. So anyway.
My biggest complaint is that I'm not getting to chill like everybody else. I'm still going to my office and doing law school work, but it's good for me. The routine of it is good for me. And I've actually worked on some big writing assignments in my office. Like we did a motion to set aside somebody's foreclosure sale.
Okay. Yeah.
It was successful. Like the sale had already happened. And it was it took like a year because I guess we didn't submit an order like the court wanted us to, and they never called us and told us. But once we found out what we needed to get it moving forward, then they finally scheduled a hearing. But I did all the writing on that, but my boss kept giving it back to me, and it was all torn up. And so I want to know that I got something from this, so I want to make sure that what I've been turning in is as it should be.
And it has been for the most part. I mean, I want to get out exactly what you've submitted, but I think it's really been consistent.
Well, what I just noticed is I was doing I just noticed that I'm still falling into that. All right, here it is. Here's the law, but here's my conclusion.
Well, and I do think we should talk a little bit about that too, but there are moments where I think that fits and that makes sense to do that, especially when you think about things like factor tests, or if you've got like 10 factors you've got to analyze, or 10 elements. I do think that there are moments where you've got to introduce the reader to like, hey, here's why we're talking about all of these elements or all of these factors or all of these pieces of law because they're all relevant. So, there's a lot of gray areas in how you do this. Clearly there are because I have one review of writing and the judge has a whole nother opinion. Or another style. So, and it sounds like your supervisor has another. And to be honest, if you want to, have a long career, you want to please your supervisor. So that's,
but he graduated from law school in 1983, so.
I do think there's an element of times are changing a little bit with respect to how people are drafting. But let's talk Wednesday at 8. I've got you down. I'll go online maybe. I think 10 or 15 minutes before. And if we're on, we can even get on a few minutes early. But I'll jump on, create the link, and then the minute you see it around 7:45, 7:50, just feel free to hop on and I'll be there.
All right, sounds good. Thank you very much.
Okay, have a good one.
See ya.
Bye. Hey, Dimitri, I think you've got your hand up. Sorry.
Yes, sir. Sorry. Thanks. Sorry for
keeping you're fine.
After. I'm gonna get caught up this week, but could I also meet with you?
For sure, absolutely. I basically was telling her, April, the same thing. Is there a time that works for you? A date, or if you want to look at your calendar, you totally can. It's the same thing. Just any time that works for you, I can be available.
What about? So I was thinking Saturday at 5. Saturday, but is Saturday good for you? Whatever's best for you. Friday is good for me, and Saturday is good for me, and afternoon Thursday. But Wednesday we got a late class and a big project. So
do you want to? Let's shoot for Friday, and the only reason is because my wife's a nurse and she works at the hospital on the weekends, on Saturday and Sunday. So it's just me and the kiddos on the weekends. It kind of makes it difficult, but I could do Friday, like evening.
Yeah, sounds great.
Okay.
Whatever's best.
What time works for you? Anytime after 5 is good for me.
Same. So you
let's say let's always 8 too late. I mean, I hate to like Friday evening, although I don't think there's much of a people's Friday nights don't look like they used to. So does Friday at 8 sound crazy to you?
You know what? Hold on 1 second. Let me check another class. I'm sorry.
Yeah, no, you're fine. And if you need to get back to me too, I mean, you can always just shoot me an email. Said something about that.
All right.
If you want to take some time.
Let me just. Well, yeah, because I might just take a second. It should be here. It just says Friday, April 10th. I don't know what time that paper's due on Friday, but I think Friday on 8 should be good. Yeah. I'll write down Friday.
Okay, yeah. All right, so I'll put down Friday at 8, and then same thing, Dimitri. I'll just create one of the links to this class. So it'll look like our class is meeting on Friday at 8, but it'll just be, us. And click the link, log in, and we can just chat. And I'll have your assignments, and I'll have gone through, and I'll just give you some advice about some of the things I've seen, some of the things I would do differently, what you've done well. And you can ask me any questions. We can talk for as long as you want.
Appreciate you big time. Thanks, and best of luck to your wife, and I hope you and your family are all safe.
Thanks, Dimitri. You too. Take care. We'll talk soon. I'll talk to you on Friday.
All right. See you. Bye.
Okay, bye.
Oh, what the fuck? She's a chatterbox.